Low Tice.
Good morning, Your Honor.
Good morning, sir.
Morning, Your Honor.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doia Banks, occupant.
Pardon?
Doia Banks, occupant.
Doia Banks, occupant, Your Honor.
Okay. So you're not Miss Whitlo?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant.
Okay, pause here. The transcript mentions a federal bankruptcy order saying the petition was part of a scheme to delay, hinder, and defraud the creditor. That phrase is a red flag in any court. Why? Because bankruptcy law protects debtors who are honestly trying to reorganize, but it punishes bad faith filings intended to stall creditors. When a bankruptcy court issues an order lifting the automatic stay and explicitly finds a scheme, it gives the creditor immediate rights to execute on property. Practically, that means BMC REO can proceed with eviction despite a subsequent bankruptcy filing unless the appellate court issues its own stay. Note the timeline. The lifting order is dated June 24th, and the judge here says no stay has been issued by the federal appellate court. That's the legal engine driving the plaintiff's motion to reopen and move for possession today. For viewers, this isn't about who's sympathetic. It's paper, precedent, and who filed what when. The record language removes wiggle room.
Of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud BMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this.
This is a civil procedure clinic moment. A woman in court identifies herself as Doia Banks, occupant. The judge asks a simple but critical question. Are you a named party? If not, the court can refuse to entertain your testimony on the merits because the case is between plaintiff and named defendants. Standing and privity matter. If you have only a lease with someone who isn't a party here, your remedy is to sue that person, not to block the plaintiff who holds title. The judge repeatedly points this out. You can't hijack a case without being properly before the court. For viewers, emotional testimony matters in public perception. But jurisdiction and procedural posture decide who can even be heard. That's why filings, proper notice, and being named in pleadings are not bureaucratic niceties. They're gatekeeping rules that preserve fairness and due process.
Order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinerest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Oh, yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlo, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlo that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that
Now watch the strategy. The plaintiff outlines multiple inconsistent bankruptcy filings, somebody in Arizona, Ms. Banks filing, and a bankruptcy preparer being forbidden from preparing filings for others. The bankruptcy court's earlier order flagged the filings as part of a fraud scheme. Why is the trial court relitigating this? Because a prior federal finding has immediate practical consequences in state eviction proceedings. The order authorized execution on the property and barred refiling for 2 years unless circumstances change. The plaintiff argues that because the federal court already found the scheme, the state court can and should reopen the eviction and enforce the creditor's rights. The judge is weighing both the procedural history and the integrity of the record. For viewers, if a court in one forum calls something fraudulent and ties that determination to the property, it becomes a heavy anchor in subsequent proceedings, especially when titled possession and huge property values are on the line.
this is $1 million house in Ann Arbor that Ms. Whitlo purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlo filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doia Banks, is respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you
rights.
are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go.
This is where emotion clashes with process. The occupant attempts to assert conditional appearance and says she doesn't consent to jurisdiction, a common tactic people try when they feel threatened by eviction. The judge's response is blunt. If you're not a named party, the court doesn't have to hear you. Then she recants, tries to fix it, and the judge rightly tells her that jurisdiction isn't negotiable on the. This exchange is a reminder. Courts operate on filings, not improvised arguments in open court. There's also a practical lesson for tenants and occupants. If you believe you have legal rights, they must be shown in pleadings, signed leases, verified bankruptcy filings, or other documentary proof. Emotion gets you attention. Documentation gets you relief.
Because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with
challenge it. With who?
With Whitlo. Miss Whitlo.
Then
Who
you
is
need to
supposed-
go against Miss Whitlo.
Pardon me?
Then you may need to go against Miss Whitlo. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part uh, that I stated that I'm not, oh, I lost my spot, not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment. Oh,
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false.
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlo.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well, and
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case
mhm,
and grant an order of a judgment and an order of eviction in
Okay.
10 days,
Okay,
Any claim of your interest in that property, you have to go after the Whitlos, because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know
Banks.
that.
Okay, I know you don't know that 'cause it's not before you.
Correct.
I see, I see. So basically, the notice of removal that the Whitlos did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so, as far as I'm concerned, any relief they're requesting, I can, and as of right, deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, you're stating to me, I want to make sure I'm clear that my issue is with the Whitlos, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have right to own the property.
Okay. All right, Your Honor, I will speak with the Whitlos that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right.
This is the video's decisive moment. The judge grants the plaintiff's motion to reopen, issues judgment for possession, and sets a 10-day vacate immediate relief for the creditor. Critically, the judge also sets an appeal bond at an unusually high monthly rate, $15,000 per month, to preserve the status quo during any appeal. Why so high? The judge expressly considered the property's significant value and the plaintiff's loss of possession for a year. An appeal bond protects the new owner from being deprived of economic benefit while the appellate process runs. Practically, a $15,000 monthly bond functions like a steep economic barrier to a frivolous or purely delaying appeal. For viewers, courts often use bond calculations to discourage gamesmanship and to force appellants who truly believe they're right to put money where their appeal is.
Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment in order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlos wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you,
Okay.
Your Honor.
Thank you.
I know, you didn't write anything.
We'll await. I did.
Oh,
No.
no, I don't think so. I don't know if Mr. Fink is ready on.
Mr. Fink, are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you, Your Honor.
Courts.
Bottom line, this hearing shows how paperwork wins in courtrooms, not sentiment. The bankruptcy court's earlier finding of a scheme to delay, hinder, and defraud created legal momentum that the state court relied on to reopen the eviction and order immediate possession. The occupant's emotional pleas and claims of tenancy didn't substitute for formal standing, verified filings, or documentary proof. The judge used the appeal bond as a tool to protect the property owner's rights and to limit tactical appeals. For Justice Desk viewers, this is a reminder that civil litigation is procedural at its core. Timing, filings, and prior orders shape outcomes more than courtroom speeches. What do you think was the $15,000 appeal bond fair? Or is it excessive? Drop your verdict in the comments. If you found this breakdown useful, hit like, share your thoughts below. And don't forget to subscribe to Justice Desk for more courtroom clarity, case by. If you want a VOQ sheet or a 2-column editor-ready file with these exact timestamps and voice lengths, I'll export it for you next.